Allahabad High Court APS Series B Exercise 18 at the speed of 110 words per minute. Be ready? Start. A plain reading of Section 5 of the Limitation Act makes it amply clear that it is not mandatory to file an application in writing before relief can be granted under the said section. Had such an application been mandatory, Section 5 of the Limitation Act would have expressly provided so. Section 5 would then have read that the court might condone delay beyond the time prescribed by limitation for filing an application or appeal if, on consideration of the application of the appellant or the applicant, as the case may be, for condonation of delay, the court is satisfied that the appellant/applicant had sufficient cause for not preferring the appeal or making the application within such period. Stop para. Alternatively, a proviso or an explanation would have been added to Section 5 requiring the appellant or the applicant, as the case may be, to make an application for condonation of delay. However, the court can always insist that an application or an affidavit showing cause for the delay be filed. No applicant or appellant can claim condonation of delay under Section 5 of the Limitation Act as of right without making an application. Stop para. In our considered view, explanation cannot be construed in a narrow, pedantic manner to mean that Section 14 can never be invoked until and unless the earlier proceedings have actually been terminated for want of jurisdiction or other cause of such nature. Explanation, which is clarificatory, only restricts the period of exclusion to the period between the date of initiation and the date of termination. An applicant cannot claim any further exclusion. Stop para. To cite an example, if a party were to file a suit in a wrong forum to enforce payment of money secured by a mortgage or charge upon immovable property for which the prescribed period of limitation is 12 years after expiry of 3 years from the date of accrual of the right to sue, and then file an application under Section 7 of the IBC after dismissal of the suit for want of jurisdiction, that application under Section 7 of the IBC would be time barred, since such party would not be entitled to exclusion of any period of time beyond the date of institution and date of termination of the earlier proceeding. If after exclusion of the time between the initiation and termination of the proceedings instituted bona fide and in good faith and prosecuted with due diligence, an application was still beyond 3 years, Section 14 would not help save limitation. Stop para. To cite another example, if civil proceedings were initiated in a wrong forum in good faith and prosecuted with due diligence, but after the proceedings ended, time was wasted by making frivolous, meritless applications, the applicant would only be entitled to exclusion of time from the date of initiation till the end of the proceedings initiated in good faith and bona fide and pursued diligently, and no more. The applicant would not be entitled to exclusion of any further time spent in pursuing frivolous further proceedings or otherwise. To sum up, Section 14 excludes the time spent in proceeding in a wrong forum which is unable to entertain the proceedings for want of jurisdiction or other such cause, where such proceedings have ended, the outer limit to claim exclusion under section 14 would be the date on which the proceedings ended. Stop. Hope you like the dictation. If you like the dictation, please like, subscribe, share with others, press the bell icon for more updates. Thank you.